84. Until the legislatures of Ontario and Quebec respectively otherwise provide, all laws which at their union are in force in those provinces respectively, relative to the following matters, or any of them, namely, the qualifications and disqualifications of persons to be elected, or to sit or vote as members of the Assembly of Canada, the qualifications or disqualifications of voters, the oaths to be taken by voters, the returning officers, their powers and duties, the proceedings at elections, the periods during which such elections may be continued, and the trial of controverted elections, and the proceedings incident thereto, the vacating of the seats of members, and the issuing and execution of new writs in case of seats vacated otherwise than by dissolution, shall respectively apply to elections of members to serve in the respective legislative assemblies of Ontario and Quebec, provided that, until the legislature of Ontario otherwise provides, at any election for a member of the Legislative Assembly of Ontario, for the District of Algoma, in addition to persons qualified by the law of the Province of Canada to vote, every male British subject, aged 21 years, or upwards, being a householder, shall have a vote. End note 39. Marginal note. Duration of legislative assemblies, 85. Every Legislative Assembly of Ontario and every Legislative Assembly of Quebec shall continue for 4 years from the day of the return of the writs for choosing the same, subject nevertheless to either the Legislative Assembly of Ontario or the Legislative Assembly of Quebec being sooner dissolved by the Lieutenant Governor of the province and no longer. End note 40. Marginal note. Yearly session of legislature, 86. There shall be a session of the legislature of Ontario and of that of Quebec once at least in every year, so that 12 months shall not intervene between the last sitting of the legislature in each province in one session and its first sitting in the next session. End note 41. Marginal note. Speaker, quorum, etc. 87. The following provisions of this Act respecting the House of Commons of Canada shall extend and apply to the legislative assemblies of Ontario and Quebec, that is to say, the provisions relating to the election of a Speaker originally, and on vacancies, the duties of the Speaker, the absence of the Speaker, the quorum, and the mode of voting, as if those provisions were here reenacted and made applicable in terms to each such legislative assembly. 4. Nova Scotia and New Brunswick. Marginal note. Constitutions of legislatures of Nova Scotia and New Brunswick, 88. The Constitution of the legislature of each of the provinces of Nova Scotia and New Brunswick shall, subject to the provisions of this Act, continue as it exists at the Union until altered under the authority of this Act. End note 42. 5. Ontario, Quebec, and Nova Scotia, 89 repealed. End note 43. 6. The 4 provinces. Marginal note. Application to legislatures of provisions respecting money votes, etc. 90. The following provisions of this Act respecting the Parliament of Canada, namely, the provisions relating to appropriation and tax bills, the recommendation of money votes, the assent to bills, the disallowance of acts, and the signification of pleasure on bills reserved, shall extend and apply to the legislatures of the several provinces, as if those provisions were here reenacted and made applicable in terms to the respective provinces, and the legislatures thereof, with the substitution of the Lieutenant Governor of the province for the Governor General, of the Governor General for the Queen, and for a Secretary of State, of 1 year for 2 years, and of the province for Canada. 6. Distribution of legislative powers, powers of the Parliament. Marginal note. Legislative authority of Parliament of Canada, 91. It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada, in relation to all matters not coming within the classes of subjects by this Act assigned exclusively to the legislatures of the provinces, and for greater certainty, but not so as to restrict the generality of the foregoing terms of this section, It is hereby declared that, notwithstanding anything in this Act, the exclusive legislative authority of the Parliament of Canada extends to all matters coming within the classes of subjects next hereinafter enumerated, that is to say, 1. Repealed. End note 44. 1. A. The public debt and property. End note 45. 2. The regulation of trade and commerce. 2. A. Unemployment insurance. End note 46. 3. The raising of money by any mode or system of taxation. 4. The borrowing of money on the public credit. 5. Postal service. 6. The census and statistics. 7. Militia, military, and naval service, and defense. 8. The fixing of and providing for the salaries and allowances of civil and other officers of the Government of Canada. 9. Beacons, buoys, lighthouses, and Sable Island. 10. Navigation and shipping. 11. Quarantine and the establishment and maintenance of marine hospitals. 12. Seacoast and inland fisheries. 13. Ferries between a province and any British or foreign country, or between two provinces. 14. Currency and coinage. 15. Banking, incorporation of banks, and the issue of paper money. 16. Savings banks. 17. Weights and measures. 18. Bills of exchange and promissory notes. 19. Interest. 20. Legal tender. 21. Bankruptcy and insolvency. 22. Patents of invention and discovery. 23. Copyrights. 24. Indians and lands reserved for the Indians. 25. Naturalization and aliens. 26. Marriage and divorce. 27. The criminal law, except the constitution of courts of criminal jurisdiction, but including the procedure in criminal matters. 28. The establishment, maintenance, and management of penitentiaries. 29. Such classes of subjects as are expressly accepted in the enumeration of the classes of subjects by this Act assigned exclusively to the legislatures of the provinces, and any matter coming within any of the classes of subjects enumerated in this section shall not be deemed to come within the class of matters of a local or private nature comprised in the enumeration of the classes of subjects by this Act assigned exclusively to the legislatures of the provinces. End note 47. Exclusive powers of provincial legislatures. Marginal note. Subjects of exclusive provincial legislation. 92. In each province the legislature may exclusively make laws in relation to matters coming within the classes of subjects next hereinafter enumerated, that is to say, 1. Repealed. End note 48. 2. Direct taxation within the province in order to the raising of a revenue for provincial purposes. 3. The borrowing of money on the sole credit of the province. 4. The establishment and tenure of provincial offices, and the appointment and payment of provincial officers. 5. The management and sale of the public lands belonging to the province, and of the timber and wood thereon. 6. The establishment, maintenance, and management of public and reformatory prisons in and for the province. 7. The establishment, maintenance, and management of hospitals, asylums, charities, and eleemosynary institutions in and for the province other than marine hospitals. 8. Municipal institutions in the province. 9. Shop, saloon, tavern, auctioneer, and other licenses in order to the raising of a revenue for provincial, local, or municipal purposes. 10. Local works and undertakings other than such as are of the following classes. A. Lines of steam or other ships, railways, canals, telegraphs, and other works and undertakings connecting the province with any other or others of the provinces, or extending beyond the limits of the province. B. Lines of steamships between the province and any British or foreign country. C. Such works as, although wholly situate within the province, are before or after their execution declared by the Parliament of Canada to be for the general advantage of Canada, or for the advantage of two or more of the provinces. 11. The incorporation of companies with provincial objects. 12. The solemnization of marriage in the province. 13. Property and civil rights in the province. 14. The administration of justice in the province, including the constitution, maintenance, and organization of provincial courts, both of civil and of criminal jurisdiction, and including procedure in civil matters in those courts. 15. The imposition of punishment by fine, penalty, or imprisonment for enforcing any law of the province made in relation to any matter coming within any of the classes of subjects enumerated in this section. 16. Generally all matters of a merely local or private nature in the province, non-renewable natural resources, forestry resources, and electrical energy. Marginal note: laws respecting non-renewable natural resources, forestry resources, and electrical energy. 92. A.1. In each province, the legislature may exclusively make laws in relation to a. Exploration for non-renewable natural resources in the province. B. Development, conservation, and management of non-renewable natural resources and forestry resources in the province, including laws in relation to the rate of primary production therefrom. And C. Development, conservation, and management of sites and facilities in the province for the generation and production of electrical energy.